Welcome back. You're watching ET Inside. The Supreme Court verdict makes it clear that the tax authorities have no jurisdiction over overseas deals done between foreign entities. But the new direct tax code may change all that going forward. I'm now joined by Zia Modi and Ketan Dalal to discuss the finer points of the verdict and to tell you what impact it will have on similar cases still being fought in courts. Ketan and Zia, thank you so much for joining me. Let me start by getting a quick reaction from the two of you on the Supreme Court verdict. So Zia, let me start with you. Surprised or stunned? I'm sure it has to be either, because no one was really expecting the verdict to go in favor of Vodafone.
In between surprised and stunned. Actually, it was something that the community did not expect. Although I know that Mr. Salve thought that he was on a winning wicket. But we just felt that given the Bombay High Court judgment and the fact that it was now the last court of the land and revenue is always involved. So a very happy surprise, reaffirmation of what we thought were the correct principles to be laid down. How they now get applied, of course, depends on case to case.
Right. Ketan, what about you?
Yeah, I would echo that. I think it's a pleasant surprise, but as Zia said, the general thought was that it would be difficult for Vodafone to get a completely sweeping judgment in its favor of the type that it has got. But I think it's an affirmation of the position of law as it stands, because if fiction was sought to be incorporated or manifested in the way it was sought to be interpreted by the tax department, and that was carrying it a little far, is what I would have thought. And in that sense, yes, absolutely pleasant surprise.
Right. The verdict which has eventually been delivered actually invokes certain principles. For example, it says you have to look at the age of the holding company, whether the transaction was done deliberately to avoid tax. But if you look at the structure behind the deal, wasn't it meant to avoid tax in some sense?
I'm not so sure, because first of all, as the Supreme Court said, the structure was in place long before the transaction got done. And in fact, the Supreme Court has referred to the timing test as one of the 6 tests to say whether or not it is tax avoidance. So I'm not sure. Also remember one thing, that the last company in the chain was actually a Mauritius company. So had the sale been executed by the Mauritius company, then on the principles of both Azadi Bachao Andolan and the Circular 689, I would have thought that the gain would have been exempt anyway. So the transaction was done at the offshore level, probably for commercial reasons and not necessarily tax reasons.
Right.
And in any case, the structure was in place long before the transaction got done, as the Supreme Court pointed out.
Right. So Zia, would you call this some sort of a milestone in the history of Indian judicial, case law and, basically the fights that happen at courts?
Milestone, it's a bit exaggerated. For me, milestones are really constitutional issues, rights of people, etc. But I think it's a very, very important judgment to give some sort of fillip to Mother India and, some sort of certainty in terms of how the companies should be treated going forward. This is not to stop the tax department from raising issues on a case-by-case basis, but at least one can show the judgment in black and white, unless, of course, the government chooses to legislate, which I hope they won't. So I think the good thing about it is that a fair degree of certainty.
Yeah, but this also, in some quarters at least, raises fear of round-tripping and treaty shopping to deliberately avoid paying taxes. So is that a valid concern to your mind?
So there are 2 issues. Round-tripping doesn't apply, because round-tripping means when you send money out of India to bring it back in. A foreigner is not taking any money back to India, he's bringing it straight in. Round-tripping may apply to Indian entities which have taken money out or come back in, but Vodafone doesn't deal with that issue. The next issue is treaty shopping. I think there the judgment makes it very clear that taking the benefit of a treaty is not necessarily a bad thing. And I would have thought that was pretty obvious, because otherwise why have treaties? Don't have treaties. No point in saying, here's a treaty but I won't let you take advantage of it. Don't have treaties. So I think the Supreme Court has recognized that tax planning is not malignant. It's not in and of itself a bad thing. You're entitled to save tax. There's always a thin line between evasion, avoidance, planning, but I think the Supreme Court has laid down some pretty robust guidelines, and they ended up being comfortable with a very complicated structure.
Okay. Now, Ketan, direct tax code hasn't been implemented yet, But that will plug this hole in terms of establishing the fact that if the value of the asset is 50% more in India, it's resident in India, then it will be taxable. So is that something which will cause confusion or will actually help in terms of giving companies clarity in terms of the M&A price?
See, there are two aspects to this, Sri. The first is that, yes, it will give clarity, but in a sense negative clarity, because what you're saying is that what the Vodafone judgment is saying is not taxable will then become taxable, assuming it is more than 50%. I don't think, by the way, that it can be retrospective, but the way the provision in the DTC was drafted is that there is an exemption if it is less than 49% or less than 50% actually. So the presumption was that as if it was already taxable. But that's a matter of semantics, technicalities. But I think I would not be surprised that if that provision is indeed legislated for future transactions. It will provide clarity for sure, just as China has done. But yes, it is in that sense contrary to the Vodafone judgment. So it neutralizes the Vodafone judgment in that sense.
Right. And Zia, what about similar cases which are still being fought in courts? For example, the Genpact GE or SAP Miller kind of case. Does this have a bearing on the outcome of those cases?
For sure. Obviously now the trump card is Vodafone, and the department's job will be to see if they can navigate around Vodafone on a fact basis, on some principle basis. But I think they will find it hard because in most of those cases the real issue is the same as Vodafone. Now there may be some treaty differences from where they've invested, etc. But absent that, I think the government would have a slightly difficult time overcoming all the both the judgments in Vodafone.
So, Ketan, on this particular provision in DTC, would you say it's a little too aggressive compared to what maybe some other countries like Australia or the UK have?
I think most countries do not have. I assume you are referring to the taxability of an offshore transaction with the underlying asset being in India. I think most countries do not have this provision. The one which clearly has this provision is China. There are two aspects to that. One is China introduced a GAR, not as sweeping as our proposed GAR, but GAR, as you know, is General Anti-Avoidance Rule. So China introduced it from 1st of January 2008, and then in the context specifically of offshore transactions, they followed it up with a circular number 689, I think it is December 2009, and the combined effect of the GAR of 2008 and this circular, which sort of is demonstrating the government's view on offshore transactions qua the GAR. From that point of view, a Vodafone kind thing was neutralized in China. But other than that, I am not aware of any country which has this. US, for example, has something called the FOPTA legislation, where, you know, an offshore transaction with the underlying asset being immovable property is taxed in US. But that's one sort of outlier and not, not general.
Okay. Now, Zia, if you talk to the tax department, they'll tell you that some of the arguments which was acknowledged by the High Court in its own judgment were not considered really significant by the Supreme Court. So is there a case for the tax authority to go in for a review petition?
There's nothing to lose for the tax department to go in for a review. But I would be very surprised if they got much further.
And why is that?
It's a very strong judgment. It's very clear on what it says. The Supreme Court has not agreed with the High Court. That's it. Somebody has to lose sometimes.
Right. But does it in general, Ketan, bolster our case for more flows into the country in terms of FDI? Does it give clarity? Do you think this is a positive from a sentiment point of view?
Yes, I think clearly there is a great positivity in terms of sentiment. By itself, it's not that transactions all across are taking place through the offshore route, because that may not be practical. That, you know, commercial reality may not be in favor of doing that. But yes, the positive sentiment is there, and of course, we must also remember that Justice Radhakrishnan's judgment has also given a lot of clarity on the Mauritius route as well, unless of course that also is neutralized, which has been the talk since last several years, but it's not happened.
Right. So I'll come back to that in just a bit. Zia, meanwhile, you read the judgment. So is there any window at all which is available to the taxman to maybe get some money out of Vodafone, to put it bluntly?
No. I shouldn't think so.
Okay. That's very clear.
To my mind.
Okay, right. So Ketan, does this verdict also impact India's treaty with Mauritius?
Yes, one must remember that the Mauritius Treaty was not the subject matter of this judgment at all,
Right.
because it was an offshore transaction and the questions underlying asset in India, is it effectively a transfer of an Indian asset? But Justice Radhakrishnan's judgment, the concurring judgment, but the separate judgment, talks relatively extensively about Mauritius and actually says that in the light of the fact that you do not have a limitation of benefits clause in the India-Mauritius Treaty, as also that circular of the Central Board of Direct Taxes, Circular 689, it is absolutely clear that the capital gain benefit of the India-Mauritius Treaty should not be denied if the selling company has a tax residency certificate. So it actually is very, very clear on that. Hopefully that will be a good relief, and a lot of transactions often get held up for that, including, I'm aware, quite a few private equity transactions. But this will provide relief. Of course, one has to see whether on the ground what actually happens, whether tax no objection certificates are issued by the tax department, which are often insisted by the buyer.
Right.
But that will pan out, I think, in the next few months.
Right. So, Zia, let me end by asking you this question. How can there be so much difference between a High Court judgment and a Supreme Court judgment? This is, in some sense, a vote fuss on the High Court judgment, isn't it?
Every time the Supreme Court allows an appeal, the High Court's judgment is set aside. I don't think it's anything particularly significant. It was an appeal that was allowed. I think that it's because everybody's expectations were not calibrated to the robustness of the judgment that we are saying, oh, look what they did to the High Court judgment. They simply read the principles of law differently. They did not have a look-through test as a matter of law. Jurisprudentially, they simply deferred with the High Court. So I wouldn't put that much stake on it. I mean, the High Court judgment, if you read it, was also a well-reasoned judgment. It's just that the judge took a different view and a different line of thinking. He didn't go wrong on facts. He just approached the law differently. The Supreme Court read it down to be more narrow and more applicable rather than widen the scope of the effects doctrine.
Right. Well, Zia and Ketan, thank you so much for joining us on the show today.
Thank you.
With that, it's a wrap on this edition of ET Insight. We'll be back next week with a lot more. Stay tuned and thanks for watching.